Hello, this is the first of a video looking at, part of a series of videos looking at pensions law, technical bites, technical issues on the new crimes, fines and penalties provisions that are coming in under the Pension Schemes Act 2021. This one's going to look at sort of an overview of the new provisions and the choices and the discretions that the regulator will have. I'm David Pollard. I'm a pensions lawyer, a barrister at Wilberforce Chambers, and this is mainly intended for professional advisors who, quite frankly, I'm not sure anybody else is going to look at this, but let's see how it goes. Later, this is such a wide-ranging area, such a big shift in the law and risk and things like that, that I want to look at this in a series of bite-sized presentations. So looking at things like what actually is made criminal or liable to penalties, what's a reasonable excuse, what happens to non-connected persons overseas, retrospection. There are all sorts of issues that come out of this that I think will be useful in small chunks. So a lot's going to depend on the facts. This is all new legislation. We haven't yet got a TPR series of practice. We haven't yet got case law, but it's going to be interesting to see how it goes. Now, this is new teeth for the pensions regulator, new dentures, it was described as by the current minister when it was going through Parliament. So Parliament has given very wide powers to the pensions regulator and has deliberately chosen not to limit them to specific acts. So it's been very broad brush in how the crimes, fines and penalties will apply. So a lot is up to the regulator about how it's going to choose to, when it will choose to bring cases and what cases it will choose to prosecute or financially penalty. So it's going to be an issue for people dealing with pension schemes or people dealing with employers in relation to pension schemes. It's not limited to employers or people who are connected or associated with employers. Is what they're doing going to be something 5-10 years later the regulator might say, oh no, that was subject to these crimes or fines. So it's going to be a stop. And one of the reasons for this is for people to stop and think, how does this impact on the pension scheme? Have I got a risk? Have I got a reasonable excuse? How would a jury decide on this? What level of risk do I want? What's likely to be the regulator's future reaction going through? So it's going to potentially catch these new provisions, many acts or omissions that affect employers, that affect pension schemes. And the major defense is reasonable excuse. It's not, I got the regulator's permission. That might be a reasonable excuse. It's not that I got a clearance. It's not that I could apply to court or anything like that. It's reasonable excuse, intensely factual, up to a jury to decide at the end of the day before the Crown Court or something like that. Two main offences, unlimited fines, up to 7 years maximum sentence. And if a company is guilty, potential for directors, managers, officers to be guilty too, potential for third parties to be guilty for aiding and abetting, counselling, procuring, that sort of thing, plus new financial penalty powers for the pensions regulator. So penal, probably not criminal, and they're done by a warning notice. The regulator issues a warning notice, then goes through a sort of court-like procedure through the determinations panel and an ability to appeal or refer it to a court, the upper tribunal, and things like that. Plus, on these two things, wider contribution notice powers, so civil remedies for money to go into the pension scheme, potentially available for the regulator as well. So the regulator has this choice between, on any one given set of facts, at least for someone who's connected or associated, they can go for the contribution notice. If you're not connected or associated with an employer, then the contribution notice isn't available, but these new financial penalty powers or criminal offences may well be available. So the regulator might be trying to do it. So the two main provisions we've got here, avoidance of employer debt. You do something that allows the employer to reduce the Section 75 debt or not claim it or something like that. And the second one, conduct risking accrued scheme benefits. So you do something that materially risks accrued scheme benefits and you don't have a reasonable excuse broadly. You've got to intend the avoidance of employer debt. You've got to know or ought to know on the conduct risking accrued scheme benefits. And both of those are also contribution notice grounds effectively. There's a new criminal offence as well about failing to comply with a contribution notice. That's a fine, not in prison, and you'll tend to know whether you've got a reasonable excuse or not, tend to know whether a contribution notice has actually been issued. So look, there are other sanctions given to the regulator for the financial penalties. This is up to £1 million financial penalty for failing to comply with the notification obligations to the regulator, including the new ones for a declaration of intent, or knowingly or recklessly providing false or misleading information to the regulator. Hopefully you're not doing that anyway. That's already a criminal offence, but now it's going to be this new financial penalty, and a new financial penalty, which is quite interesting, knowingly or recklessly providing false or misleading information to trustees in an occupational pension scheme. If you do that, then the regulator can fine you up to £1 million. And that applies to anyone giving information to trustees for the purpose of carrying out their functions. So it could include members, could include employers, could include third-party insurers, could include lots of people, could include the government, all sorts of people you could do that. And it's a knowingly or recklessly. So should you have known it was wrong? Was it false or was it misleading? Yeah, did it not give the full story? That might be quite an interesting one as we go forward. The regulator is the prosecutor and the penalty decider on this. It's a challenging role for the regulator, probably 3 stages of risk. Will the regulator investigate? It's got powers to claim, get information. It's going to get information as of right under these declarations of intents and things like that. The power to get information on Section 72 notices is already quite wide-ranging, probably doesn't apply overseas. There's been a recent Supreme Court decision in another area on that. Then the second risk is that the regulator, having looked at this, decides whether or not to prosecute or look for a financial penalty. No time limit on that. Could be 10 years down the track. Obviously, it's going to be based on what was happening at the time the relevant act or omission to act took place. And then the actual criminal trial or hearing before the determinations panel. So people dealing with employers and with pension schemes are going to need their advisors are going to need risk warnings, rather like those medical adverts you get with warning this can cause death. You're going to have that at the bottom, hopefully in a very short burst. In practice, will this apply? How often will this apply? Will it only be really nasty cases? We don't know. The regulator will want to use it as a deterrent, will want to be seen to be acting. It got criticised, I think unfairly, by the government and by select committees for not having used its powers earlier. I think that was all rather silly, but then that's the government, not me, or the select committee, not me. So how's it going to go through? So there's a TPR policy on prosecution that is issued. Actually was pretty helpful. It's a draft at the moment. I think there's going to be much more involvement of TPR, of the regulator. If you're doing something and you tell the regulator, they're not going to give clearance for criminal stuff, but actually if you tell them and they don't object, or they only object vaguely, then that looks like a reasonable excuse quite often. It's going to be more difficult to show a reasonable excuse if the regulator wasn't aware of what was going on. Is silence going to be consent? I don't know. And then in terms of how the regulator is going to react, it's got this sort of contribution notice or financial penalty or crime in deciding how to go forward. And they all have different effects. I've done a comparison table, which is going to be, which is in the slides, which you can get by clicking the link in the caption above. So looking at things like who's the tribunal, who could potentially be a target, what happens to the money. So for the financial penalties and the crimes, any penalty or crime money that's received doesn't go to the scheme, it goes to the Crown, it goes to the possibility of compensation orders and things like that. So those are going to be debates that the regulator has. In practice, hopefully, this is only going to apply if all the wheels fall off an employer says an insolvency and there's a claim being made and they think it's outrageous conduct or something like that, but we shall see. So if you have any queries or thoughts or comments, or you want to discuss any of this, please do contact me, the detail at Wilberforce Chambers, and it will be great to hear. And then we'll go on to another one and look at particular issues going forward, like reasonable excuse and that sort of thing. But thank you for watching and listening.